Everyday injustice. Too many wrongful convictions. Corruption has infected the criminal justice system, leaving too many people helpless, fighting for their lives. Instead of receiving justice, people suffer. Is that why they say justice is blind?
Hello, and welcome to the Everyday Injustice Podcast. I'm your host, David Greenwald. For the past 10 years, we have operated Vanguard Court Watches in California, including San Francisco, Sacramento, and Yolo counties. Our goal? Expose everyday court injustices, and now, more broadly, shine a spotlight on injustices in the entire criminal justice system, in the form of wrongful convictions, police and prosecutorial misconduct, and mass incarceration. This podcast hopes to take it a step further and highlight criminal justice reform on a national level.
Everyday injustice.
Today on Everyday Injustice, we have returning guest, Daniel Medwed. Welcome.
Thanks, David. I guess I'm a recidivist guest.
Yes, although I'm not sure we really want to use that term these days.
I don't think we do.
It's really interesting. Earlier this week, I did an interview on the Andre Thomas case out of Texas, which is probably one of the more disturbing death penalty cases that you would ever see. It's not a wrongful conviction case, but it's got pretty much everything else in it, including some pretty racially charged stuff and some mental illness and gouged out eyeballs just for fun, right?
Yeah, it's really amazing. Some of these death penalty cases, as horrific as the underlying crime might be, learning about the process and how the defendant is treated throughout the process is often quite horrific as well.
So, one of the things that we were looking at was an article you did a couple of years ago, Black Deaths Matter and the Race of the Victim Effect, which is really interesting in a not so good way, but definitely interesting how much the victim, the race of the victim actually drives the seeking of the death penalty, whereas you might think that racism would show up, with the race of the person who actually committed the murder, but that's not really true.
I think you're right. A lot of people, if you just talk to someone on the street and you say, hey, is the death penalty racially biased? I think a lot of people would acknowledge yes. And then if you ask them, in what way do you think it's biased? They would probably say, well, more people of color are sentenced to death and put to death than white folks. And then if you respond by saying that's actually not true, white people are more likely to be sentenced to death and to be executed, they'll be a little bit shocked. But then when you give the explanation, it seems to make sense, which is that most crimes that are eligible for the death penalty are murders. Most murders, of course, are intraracial, white people killing other white people, black people killing other black people. And because of the premium that our society horribly puts on white lives, white victims of cases like this often get better treatment. They get greater treatment, more deference, more respect from prosecutors, which manifests itself in a higher rate of capital charging in cases involving white victims. So it is paradoxical and incredibly disturbing, but when you unpack it, it sort of makes sense given the racist origins and longstanding ramifications of life in our country.
So, I understand this, like from a statistical standpoint, that, most crime, despite what people may think, is actually, intraracial, right?
Yes.
You have a white victim of a white perpetrator much more often than you have a white victim of a black perpetrator. And of course, we've heard all the nonsense about, there's a black on black crime wave type of thing. But what accounts for how the system actually processes and then treats different victims differently. And is this overt or is it subconscious, or how's that working?
Yeah, David, that's an amazing question. I mean, my impression is that it's entirely covert. You know, prosecutors wouldn't come out and say, "Hey, we are valuing this person's life more than another person's life." If you look at the data, it reveals that, and then we look beneath the data to try to figure out why. And this is just speculation on my part, but part of it, of course, is that the prosecutors are suffering from some implicit biases, where they might be identifying more, because most prosecutors, of course, are white, they might be identifying more with the victims who are white. They are empathizing more with them as potential brothers and sisters and parents and children of themselves, and just subconsciously are valuing them more. The other piece of it is that because of white privilege and socioeconomic status, it's quite possible that the white victims' families are better positioned to clamor for the death penalty, to communicate with victims advocacy groups, to communicate with prosecutors' offices and have their voices heard, and maybe somehow encourage prosecutors to pursue the death penalty. Again, that's sort of speculation, but that's another part of this. Regardless of the explanation, I think this is one of those situations where the data tell a really sobering story. And one thing I mentioned in the article you referenced, and I really appreciate that you read it, is I give an example of two different cases from Texas involving women victims at the age of 32, one a black victim, one a white victim, and how in the case of the black victim, the perpetrator was given a life sentence, and in the case of the white victim, the perpetrator, who was white, was given the death penalty. And even though, of course, these are different cases in different counties, I think it really shows some of the perverse outcomes here. Yet another reason, David, why I think the death penalty needs to go away. We just cannot ensure equity in its application.
Yeah, and the other factor I suspect is that part of the system is looking at the impact of a crime, and there's probably a socioeconomic component to this as well, that if the white victim, let's say, is a college professor and the black victim is a poor working class person, the prosecutor may subconsciously value the life of the college professor more than the working class person.
I think there's something to that, which is that all of the racial inequities that we see in society, including correlation between race and socioeconomic status, also infiltrates, I think you're right, the criminal justice system. Now, to be sure, there are a lot of white crime victims who aren't of means and maybe lack access to the levers of power and to make some noise. But I think you're right. As compared with many black victims, they are better positioned to do that. And regardless of their precise socioeconomic status, there is that question of white prosecutors identifying more with other white people. And until we diversify the police and prosecutorial ranks so that basically law enforcement looks like the types of folks who are embroiled in the criminal justice system, both alleged perpetrators and victims, I think we're going to continue to have a lot of these biases.
So I do want to invert this question a little bit, because I saw something really interesting almost exactly a month ago. So down in Riverside, California, which for those who aren't familiar is kind of this eastern portion of the LA metropolitan area. It's kind of large in its own right, but it's also much more conservative than, say, LA County. There was the ACLU and the Public Defender's Office filed a very interesting motion to get the death penalty for two completely separate defendants in completely separate cases thrown out under the California's Racial Justice Act. Now, the Racial Justice Act was just implemented a couple of years ago to kind of deal with some of these racial inequities. And the data that they came up with was really fascinating because it found that, for similarly situated crimes, somewhat comparable circumstances, that Black perpetrators were like 5 times more likely in Riverside County to receive, a death penalty charge as opposed to white defendants. So your thoughts on that?
Yeah, I mean, that's sort of interesting. I'm not aware of the situation in Riverside. I'd love to see your data and where that comes from. Do you have any thoughts, since you're closer to that situation geographically, at least?
Well, it was really interesting because, the judge in that case ended up deciding that the situations weren't similar enough to the white examples that he was willing to grant it. Now, I think, this judge is a little conservative, and so it's going to be interesting to see what the appellate courts end up doing with this case. But I mean, the number of cases was astonishing, in a county that's not really very Black. To have, I don't know, I'd have to pull it up, but it was a very high percentage of death penalty cases involved Black defendants, which was really interesting because, as you mentioned, and as my understanding of the data suggests, overall that's not the case, but I guess on a area by area basis, it could differ quite a bit.
Yeah, I mean, one thing that would be interesting there, David, is to see the extent to which some of those cases involved interracial killing, situations where maybe there was a person of color accused of killing a white person. Because the data certainly suggests that even though the race of the victim effect is the biggest effect, that if you are a white victim, you're more likely to have the person who is charged accused of killing you, subject to the death penalty. Black perpetrators who kill white victims have the highest rate of the death penalty, right? So there's definitely, it's not as if the bias against Black victims is contained to victims. It also pervades how Black defendants are also treated. And I think that points to a really, really important issue that you alluded to, David, which is how to compare these cases. If you're trying to figure out whether similarly situated cases are treated differently, it can be an exercise in futility because you can always distinguish the case in some fashion, right? The perpetrators aren't going to be exactly the same age, with the same criminal history, with the same mental health profile. The cause of death and the manner of death isn't going to be identical. So it's really, I think, easy for defenders of the system to point to these differing results and say, well, you're going to expect differing results because there are different cases with different variables. But if you strip these cases down to their essence, statistically, there should be no reason why race should be a factor, right? These decisions should be based completely divorced from the race of the defendant or the race of the victim. And that's what I think is very troubling. One of many reasons why we find these data sets very troubling.
Yeah, and I was kind of chuckling as you said some of this because there was kind of gymnastics hoops that the prosecutor was kind of going through, but the judge was buying into it. There are all these differences here. Of course, you can always find differences. And, on the one hand, neither of these cases were kind of gray area cases that, if you believe that there's a death penalty, you're probably gonna be kind of thinking this case, kind of might qualify for it. So it's not like these were gray area cases, but, bad cases make for good law or some statement like that, right? I mean, most of the, a lot of the critical cases in history have not exactly been sympathetic.
Right.
Look at Miranda, for instance.
Exactly. Yeah, Ernesto Miranda wasn't a sympathetic defendant.
Exactly.
In the famous Gideon versus Wainwright, Clarence Gideon wasn't a very sympathetic defendant. In Strickland versus Washington, the ineffective assistance of counsel case from the 80s, David Washington wasn't a sympathetic defendant. So I think that's right. The nature of the background facts plays a role in how the doctrine is constructed.
So this is, I just pulled this up as we were talking, just to put some data behind this, because it's
Yep.
really interesting. And they actually asked Frank Baumgartner, who we had on a few weeks ago.
Yeah, Frank, he's great. He's done a lot of really interesting work on the death penalty in North Carolina.
Right. And so since 1972 in Riverside County, 66% of those sentenced to death have been Black and Hispanic, while only 24% have been white. And then since 2005, it's up to 70%, so almost 3 to 1. In a county that's, probably if we were looking at the Hispanic population, it'd be fairly high, but the Black population is probably somewhere around 10%, maybe lower.
Wow. I mean, a couple of things I'd love to know about Riverside then. What is the racial and ethnic composition of the DA's office? And also, what about the racial and ethnic composition of the crime victims in those cases? Those would be really interesting data points. Maybe Professor Baumgartner knows that as well.
Yeah, for sure.
Yeah.
Anyway, I mean, this is just one example of kind of the skewing of the circumstances. Going back to kind of your research, how do the courts kind of deal with the race issue? And you bring up, of course, the Furman case out of Georgia, and of course, the parallel to the California Racial Justice Act is that California was trying to fix, at least at a state level, Furman by implementing the Racial Justice Act. But how does the Furman case kind of limit what we can do with race?
That's a really good point. So when you look back to the 1970s, of course, the reason why the death penalty was discarded just temporarily for 4 years was this idea that it was arbitrary and capricious and that it was rife with racial bias. So one way that states tried to change their regimes so that it would pass constitutional muster is to remove some of the discretion for prosecutors and have very fixed aggravating factors that prosecutors would have to cite in deciding whether it's a death penalty case. So now there are statutes in these jurisdictions, in the 30 states or so that have the death penalty, that'll say, hey, you can only charge something as a death penalty case if there are multiple victims, or it was a police officer, or it involved a weapon of mass destruction, or what, there are various statutory criteria. The problem, I think, with that is, even though the Supreme Court later determined in the 70s that that was enough to give them comfort that there were some protections against the arbitrary and discriminatory application of the death penalty, what we know is there's still a lot of flex in the joints. There's still a lot of room in that type of aggravating circumstance regime for prosecutors to display discretion in picking and choosing. It comes down, I think, to this whole idea of discretion. On the one hand, our system is predicated on discretion. Discretion for the police to make an arrest, discretion for prosecutors to charge a crime, discretion for judges to apply certain sentencing. And we want to give actors some discretion. We don't want to make it too mechanistic, too mechanical, because there has to be a human element in the system. But on the other hand, if something is given too much flex in the joints, there's too much leeway, then there is always going to be an opening for the possibility of implicit racial bias. And I think that's the problem. We still don't have a good mechanism for clamping down on implicit racial bias. Because you can present this data to people, right, David? You could be like, look at the disparate impact of capital punishment charging in Riverside, California. And as you said a moment ago, courts might go through mental gymnastics to justify the data. Well, in this case, there was this aggravating factor, whereas in that case, there's not another one. So I think the problem is maybe we should limit the discretion on the front end of law enforcement and have a more rigorous vetting on the back end by appellate courts and in the habeas corpus process. And that's something that a lot of my other research has talked about, which is, contrary to popular opinion, there aren't many robust appellate and post-conviction procedures out there to take a close look at potentially unjust trial outcomes. And I think we need more of them. The other piece of this, which I think is really interesting, and I know you know a lot about this, David, relates to Batson claims and crafting racially slanted jury pools, right? Or racially tainted jury pools. In theory, there are lots of safeguards against creating a jury that is monolithic, that is homogenous, that is not representative of potentially the defendant's background. But in practice, there are a lot of loopholes that will allow prosecutors to avoid that.
So I want to go back to one of the points that you made in a second, but I just want to kind of follow up because you were talking about aggravating factors, and it seems to me that what's actually happening is a lot of these aggravating factors have racial coding into them. And so this implicit bias is actually coming up because some of these aggravating factors are not race neutral as we think they are.
Oh, that's interesting. I think that could very well be the case. I admit I haven't taken a deep dive into the different aggravating factors in different jurisdictions and sort of correlated them to see what some of the trends are. But I think that's quite possible. And that goes back to, again, to some of the implicit racial bias that might have been animating the drafting of the laws that created these aggravating factors, that certain types of crimes are worse, right? Certain types of deaths, certain types of homicides are worse, which I think you're right, which may reflect some underlying norms and values that, for lack of a better term, are white-centric views.
And then, the other point that I think you made, and we talked extensively about when we met last time, is the fact that there's just no fail-safe in the system. Right. And so, we have this opinion of the appellate courts that, they're throwing out all these cases on technicalities. And the reality is that you see these people that have been in prison for a long time. And I was just reading this book about all these, these drug cases that were charged in the federal courts and how hard it was, even under the Obama administration, to get clemency to rectify some of these situations where people, got life sentences for relatively minor crimes. And then, wrongful conviction cases are really difficult to get thrown out. And so, it's just as hard when you have all of these kind of, I don't want to call them soft racism, but, this implicit bias racism where, you can't point to, the prosecutor using the N-word, although, right. In my discussion earlier this week, that actually happened. And the court still wouldn't throw it out. But
it's unbelievable.
It's just astonishing. So, you get these cases and a lot of these are not very sympathetic cases. And so, it's like, it's not like you're talking about an innocent client, but yet, when you add up the sum total, creates this humongous racial disparity in the system.
I think that's right. And I think it goes to something that you also talked about before, which is you referred to it as soft racism. We could talk about it as an implicit racial bias. But the trick is, how do you identify that? Right? How do you not just identify it, but call it out in a way that's compelling enough to reverse a conviction, compelling enough to reverse a unanimous decision of 12 jurors? A unanimous decision in a death penalty case, often of 12 jurors at both the guilt phase and the sentencing phase. And I think that's part of the challenge for appellate courts and judges on habeas, which is they see it maybe, or they understand it, but they might not feel as though it's egregious enough to warrant overturning it. And this points to something that I think is really perhaps the most important piece of it, is when these cases are charged at the front end, and they're charged as a death penalty case at the front end, it's almost as if the boulder at the top of the hill is starting to fall down, and it gathers momentum, and it's inexorable, right? It's almost impossible to stop it after it's already started. So you could have better back-end reforms to filter out these cases, but what we also need, David, is we really need front-end filters to keep these cases from ever going to trial. Part of that, of course, could be getting rid of the death penalty entirely, but short of that, we could have additional screening mechanisms in place in every DA's office, maybe have an external screening mechanism of bipartisan, neutral observers to look at these cases from a more objective perspective. But I think you're right. These cases are pervaded. They're infected with implicit bias. But detecting that, identifying it, quantifying it, calling it out as something that's worthy of reversal is sometimes a challenge.
And this is really what California was trying to do with the Racial Justice Act, is give a tool to get rid of some of this stuff before it gets baked in through a jury verdict. And what I saw is that that's going to be a little bit harder than you think, depending on where you are. Now, it's interesting because, and I don't know what happened with the case, but at the same time as the Riverside case, there was another case. It wasn't a death penalty case in San Francisco, but the judge did grant an evidentiary hearing in that case under the Racial Justice Act. It was a special circumstance case where they were arguing that Black people are more likely to be charged with special circumstance murder than white people. Now, the weird thing about California is we have a death penalty, but we don't have a death penalty.
Right. When's the last time there was an actual execution in California? It's been a while, right?
It's been, I don't know, 18 years or something like that. And there's a moratorium, and now the governor has not gone in and commuted the sentences of death row, but they're clearing out death row.
Yes.
And so it's this weird dynamic. We have a death penalty on the books. Some counties will charge it, other counties won't. So like San Francisco has never charged a death penalty case. Riverside has like, in that courtroom, they're going to hear 3 death penalty cases this spring and summer.
See,
it's insane.
Yeah, that's one of the things that has always troubled me about the death penalty. It's one thing for a state to decide that it wants to have the death penalty, but the fact that your likelihood of getting the death penalty is dependent so much on the randomness of where within that state you live is pretty darn shocking, or where within that state you might commit a crime. When I was in New York had the death penalty for a relatively short period of time in the 90s under Governor George Pataki. And I was a defense lawyer in New York at the time. And I remember that the DA in Bronx County in New York City just didn't charge the death penalty as a matter of policy. He didn't believe in it. But the DA in Queens County did believe in it very vociferously and very strongly. And the idea that you could live in the same city, but you're in a different borough, and a lot of people in New York don't even realize that the different boroughs are different counties, and that could be a complete factor in whether or not you're sentenced to death, was always just bizarre to me. I agree.
Yeah, I mean, if you are in the eastern part of LA County and you commit the same crime and then go over the border into Riverside County, you're going to get 2 different punishments.
Yeah.
So, because LA County, they're not going to charge the death penalty, and Riverside County, they will. And so,
and that rationale applies to state lines. I get that, right? If you're on the highway in Nevada, you're going to face different, problems than if you're on the highway in California, because the laws are different. I get that, assuming it's not a federal land. But within a state, right, I think most people don't realize the discrepancies. You're exactly right, between LA County and Riverside, Bronx County, Queens County. Here in Massachusetts, between Middlesex County, where Cambridge is, which is where I live, separated by a river, from Suffolk County, Boston. That's it. Just so you go over a bridge and you're in Suffolk County, but the law could be very different in terms of its practical application.
All right. What's your remedy here? What's your conclusion?
David, and you won't be surprised about this, but I think when it comes to the ultimate punishment, the death penalty, we just have to abolish it. It does not work. It is not workable. Some of the problems that were identified by the Supreme Court in the 1970s about the arbitrary and capricious application continue to apply despite all of the statutory aggravating factors and all of the vigilance and supervision by courts and others in this area. We are still getting situations where race seems to be an outcome determinative factor in many cases in deciding who lives and who dies. Sometimes just the race of the victim, but still the racial components are propelling the result. And there also are far too many examples of potentially innocent or actually innocent people being sentenced to death. Some of them have been freed from death row. Some of them, we don't know if they were ever freed from death row, and we may never know. So I think the solution, frankly, is abolition. And anything short of abolition here is only a partial solution. And it will never remedy the problem. It might just minimize it around the edges.
Yeah, and I mean, I've been an abolitionist on the death penalty for over 30 years. So wow. I'm not going to argue with you on that point. Yeah. The only point I would add to that is that you end up just shifting where the locus of injustice is.
It's life sentences.
Then it becomes life without parole becomes the focal point instead. And, you can argue whether or not, you should be sentencing people to die in prison, death penalty of a different sort. Yeah. And then you can find the racial justice implications of that one.
You know what? And you're 100% right, David. Here's my approach to that. I'm an evolutionary, not a revolutionary, which is you tackle these problems in sort of gradual piecemeal steps. And if the death penalty is the most egregious example of racial injustice, in part because the result of the death penalty is so final, there's no appeal from the grave, as Professor James Acker said, well, let's first get rid of the death penalty, and then we can focus on life without the possibility of parole, which I agree with you, has its own set of problems. Some people would say that life without the possibility of parole is perhaps a greater injustice than the death penalty. I would disagree with that, only because with LWOP at least, you can have people out there advocating for someone who's in a cage and fighting for them, and there's a possibility of a change. There's a possibility of a remedy. Whereas capital punishment, of course, is final. As I said a moment ago, there's no appeal from the grave. You can't reverse that outcome after it's occurred.
No, and I definitely agree with you on that. My only point was, the system is the problem. The death penalty is just the most glaring example of that.
You're
problem.
Exactly right. There might be an illness with lots of different manifestations of that illness. And my view is go with the one that's the most painful, the most brutal, the most potentially fatal. And once you've tackled that one, go to the next. And I think one of the problems is trying to figure out, there's a triage going on, figuring out what is the most egregious injustice in our system. And I think different people could have different views on that.
All right. Well, I will let you have the last word on that. As always, I appreciate you coming on. Very interesting discussion. I'm sure we'll be talking about this more in the future.
Absolutely, David. It's always a pleasure to come on. Just let me know if you ever need me again. Keep up the great work.
Professor Daniel Medwed has been talking about the death penalty and the implicit racism in the system. This has been Everyday Injustice. I'm your host, David Greenwald. Join us again next time for more tales from the injustice system.
Thank you to George Powell and Norman Mousequake Barrett for the use of our opening, Everyday Injustice. You can see more of George's music at www.justiceforgeorgepowell.com. That's Justice for George Powell, all one word, .com.